This is Michael Popok, Legal AF. Happy Juneteenth, and the federal courts are still working, even though it is a federal holiday, and we have an order from Magistrate Judge Reinhart, who will be the day-to-day magistrate judge for all things Donald Trump, Mar-a-Lago, and the Miami prosecution. Sitting in West Palm Beach, he issued an order today, a protective order that will govern all things discovery material. Discovery material is the data, information, witness statements, documents, evidence that the government is compelled by our Constitution to turn over to the defense under a line of cases that starts with Brady. So it's called Brady material. So they have to do their job under due process and constitutional concerns, the prosecution, to turn over the Brady material, but the defense has to do their job and make sure that all that Brady material stays right where it is with defense counsel, the defendant, and doesn't get disseminated or disclosed to the public on social media or otherwise. Now, this protective order motion that got signed today on the 19th is not a terrible surprise. Last week, the government, working with the defense counsel for Trump and Walt Nauta, agreed to the terms of a protective order to accelerate the disclosure of this information and provision of this information from government to defense counsel. With one caveat I'll talk about on this particular hot take, which is for that material that is national security or national defense information or classified in any way, the lawyers and others have to get security clearance in order to review that material. So just because a protective order was signed today doesn't mean that the fire hose of data, information, and Brady material is going to come shooting out of it all the way to Donald Trump and his lawyers. Parts of it will, those that aren't classified, those that aren't under a top secret or classified system of classification, but not all of it until they get their security clearance. That answers the questions that many people have, which is, how do people that don't have security clearance get to look at classified, top secret, and national defense information, NDI? And the answer is they don't. They have to get clearance. And last week, the judge currently in the case, Judge Cannon, issued an order that all the lawyers on the defense side hurry up and submit their applications and processes to the federal government to get their security clearance, because that's about a 30-day process. So we don't expect, even with the protective order in place, we don't expect that the NDI, the top secret classified documentation, is going to go over to the Trump side until they get security clearance. Now, the protective order is very strict. It's short, it's sweet, but it's very strict about the use of the discovery material. Firstly, it is under lock and key by the defense team and the defense counsel. The judge will look to the defense counsel and find them in contempt if any of his aspects of his order are violated. They need to catalog and label all versions, hard copy, electronic, or otherwise, that they obtain of this material. They need to know where it is at all times. They need to know where copies of it is at all times. And all that has to be cataloged. The defense team and the defendants, Trump and Nauta, can take notes, but even those notes have to be under lock and key, cataloged, and kept and segregated with the discovery material. There can be, in two different sections of the protective order, in Section 3 and in Section 6, the magistrate judge took pains to warn primarily Donald Trump that there will be no disclosure indirectly to anyone other than an authorized group of personnel that are working with the defense team as experts or other lawyers. And even they, in getting it, can't take copies, can't make copies, and have to sign a certificate that they understand the terms of the protective order, which could subject them to contempt if they violate it. And then there's a section 6, in which the magistrate judge warns Donald Trump that there shall be no disclosure to the public on social media, or otherwise, without the consent of the prosecutors and sign off by the court, Judge Reinhart. There's a little bit, just talking as a drafter of legal documents, there's one extra thing I would have added, just to nerd out here for a minute, on Section 6. I would have added directly or indirectly after the words disclosure, just to make it clear that, like, Don Jr., Eric, or somebody else, some sort of lackey or surrogate for Donald Trump, doesn't get it. But I think when you read the entire order from Section 3 down to Section 6, I think it captures the essence. And if anybody tries to, if Trump then takes the document and gives it and leaks it to Roger Stone, for instance, just to name somebody, and Roger Stone then tries to, go on Newsmax or Steve Bannon's podcast and talk about it, I think Trump, Bannon, and Stone will be in deep trouble under this protective order. If you have a family like I do, you know how much your loved ones depend on you. In a worst-case scenario, you wouldn't want them to worry about money. Policy Genius was built to modernize the life insurance industry. Their technology makes it easy to compare life insurance quotes from America's top insurers, and in just a few clicks to find your lowest price. With Policy Genius, you can find life insurance policies that start at just $25 a month for $1 million of coverage. Some options offer coverage in as little as a week and avoid unnecessary medical exams. Policy Genius has licensed, award-winning agents who can help you find the best fit for your needs. They work for you, not the insurance companies. That means they don't have an incentive to recommend one insurer over another, so you can trust their guidance. Policy Genius is for parents, caregivers, and anyone else who has people who depend on them. They simplify the process of getting life insurance so you can protect the people you love. There are no added fees, and your personal details are private. No wonder they have thousands of 5-star reviews on Google and Trustpilot. Your loved ones deserve the financial safety net. You deserve a smarter way to find and buy it. Head to policygenius.com or click the link in the description to get your free life insurance quotes and see how much you could save. That's policygenius.com. And the judge actually spells it out in Section 9 of the protective order when the magistrate judge says any violation will be in contempt of court and will subject that person to both criminal and or civil sanctions. Civil sanctions are usually fines that could have some impact on the trial itself. Criminal is what it sounds like. You could get locked up for it. You could spend some time in jail for having violated this. So this is a necessary piece. It also shows you sort of the ordinary pace of this garden variety criminal prosecution of a former president on 37 counts, including 31 counts of Espionage Act. And I'm only saying that slightly tongue-in-cheek. Donald Trump is now in a federal process. Donald Trump is being treated like any other common criminal in federal court, except at the beginning when, we all sort of are pissed off that the magistrate judge Goodman, the day magistrate on Tuesday that actually got picked to handle the pretrial release issues and the bond and bail issues, if there were going to be any for Donald Trump, we wanted, put him in prison, lock him up, federal detention center before trial. That wasn't going to happen. Take his passport. Government didn't ask for it. Have other requirements of probation, have him check in regularly, have him never leave, Florida without permission. But these are not things that the federal government asked for. There's a little bit of, I'm trying to think of the word for this. I was going to say timidness, being timid by the government. They are, using kid gloves around Donald Trump because of the accusations that if they go too hard on him, that it's too partisan. So they're kind of bending over backwards the other way to give him a little bit of leeway as the leading candidate for the Republican Party, even though it pisses the rest of us off. But not so with Judge Reinhardt. He's the one to remind everybody, or those that are just coming to the program for the first time, Judge Reinhardt's the one that issued the search warrant last August that was executed on Mar-a-Lago. So Reinhardt has a very deep understanding of the players here and the law, of course, in this area as a sophisticated and veteran, experienced magistrate. And, my point is that on a kind of common practice, protective order being put in place, exchange of documents or the documents coming from the government over to the defense, this is going to go matter of course. The next time something really, really important happens is we're going to see a confirmation that the defense team has secured their security clearance to allow for the full exchange of documents or the full production of documents from the government over to the over to the defense. That's one. And then we're going to see, I guess Eileen Cannon having her first hearing in which they're going to talk about the calendar and the timeline, setting the time for the inevitable motion practice, motions to be filed by the defense team to dismiss the indictment or attack the grand jury process or suppress evidence. Like, they don't like the fact that all the attorneys got stripped of their attorney-client privilege, or technically Donald Trump got stripped of his attorney-client privilege and the attorneys were compelled to testify over it. They don't like that, so they'll move to suppress that. They're going to argue that somehow the search warrant was invalid or improperly issued. Good luck, since Magistrate Judge Reinhardt handled that, and try to suppress that evidence that came from the Mar-a-Lago search. So there's going to be all this motion practice, this flurry of motion practice. And the question is when? When is that going to happen? Right now we're in June. It's not going to be a June event. It's probably going to be a hearing in July or August in front of the judge, Judge Cannon, where she says, all right, you got, let's start with when the trial is going to be and work our way backwards. And that's when we're going to know when the trial is going to be. Understanding that this patchwork of calendaring around the other 4 to 8 criminal and civil trials for Donald Trump and how do you place them is going to matter. We already have one judge in New York, Judge Merchan, who set a March 2024 date for his 34-count business record fraud case against Donald Trump in New York State Court. And now Cannon's going to have to come along and set a trial based on the prosecution. They want as speedy a trial as possible. They're not going to go 70 days. That's the standard speedy trial. They're going to do it. It's going to be longer than that. But they're going to want, first quarter 2024, second quarter 2024 for this trial. And then you work backwards to set the dates for the motions to be filed by the defense. And if somebody doesn't like the results of those motions, there's going to be inevitable appeals. So we've got that whole process going on. We're going to follow it here. I do it at the intersection of law and politics about every day, only on the MeidasTouch Network. I co-anchor and co-founded the leading political and legal podcast also on the MeidasTouch Network called Legal AF. That's on Wednesdays and Saturdays. And I'm co-anchor that with Ben Meiselas and Karen Friedman-Agnifilo. If you like what I'm doing on this podcast, on this hot take, give me a thumbs up. It helps with all things that matter, including the quantity and quality of what we're doing here. And you can follow me, Michael Popok, on all things social media at MS Popok. This is Michael Popok, Legal AF reporting.
Hey, Meidas Mighty. Love this report? Continue the conversation by following us on Instagram at MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.